Okay, good afternoon, and welcome to the annual E.L. Wiegand Visiting Fellow Lecture on How Good Tax Lawyers Go Wrong, Aggressive Tax Planning, Bounded Ethicality, and the Meaning of Ethical Tax Lawyering. I am Susan Freewald, the Dean of the Law School, and I'm particularly delighted by the topic of today's lecture because here at the University of San Francisco School of Law, it is our mission to graduate excellent and ethical legal professionals to serve many communities. I want to begin our lecture today by thanking the E.L. Wiegand Foundation and the E.L. Wiegand Trust for their generous and sustained support of the graduate tax program here at the University of San Francisco School of Law. Since we started the program, the E.L. Wiegand Visiting Fellows Program has brought distinguished tax experts like Professor Field to our campus to engage our community in timely and insightful discussions. I would like to introduce Professor Daniel Lathrop, the E.L. Wiegand Professor in Tax, who will introduce Professor Field as our E.L. Wiegand Visiting Fellow today. Professor Lathrop is an exceptionally gifted teacher who has launched the tax careers of many of his students, some of whom are surely here today. He is an expert in several fields of taxation, having authored numerous casebooks and treatises that he regularly updates. We are so lucky to have him here today and as the academic director of our graduate tax program. Before I hand it over to Professor Lathrop to introduce Professor Field, I just want to thank Julie Chernoff, Margaret Mullane, and Kenji Kahano for bringing this event to you today. Professor Lathrop.
Thank you, Dean Freewald. I want to add my welcome to everyone who's joined us here today. Today marks the 5th E.L. Wiegand lecture. The lecture has quickly become the premier annual event of the graduate tax program at the University of San Francisco School of Law. Over the past several years, the lecture has featured presentations by nationally recognized scholars, a top government official in the United States Treasury responsible for national tax administration, and an international leader in the tax profession. The success of the graduate tax program and today's lecture are attributable to the vision and the efforts of many individuals and many institutions. At the top of that list is the support that's been provided by the E.L. Wiegand Foundation. And I want to personally acknowledge the foundation's support of the graduate tax program and today's lecture, thank the trustees of the foundation, and thank Kristen and Skip Avancino for their leadership and support. Thank you. As the Dean mentioned, this year's E.L. Wiegand Annual Visiting Fellow is Professor Heather M. Field. Professor Field's topic today is How Good Tax Lawyers Go Wrong, Aggressive Tax Planning, Bounded Ethicality, and the Meaning of Ethical Tax Lawyering. In her talk, Professor Field is going to examine the timeless but always evolving issue of the boundaries that a tax lawyer must navigate in making discretionary decisions regarding advice to a client on whether to take aggressive tax planning. Professor Field is eminently qualified to address this topic, provide us with some perspective, and suggest real-world tax advice for tax professionals. Professor Field is a professor of law at the University of California, Hastings College of the Law, where she also holds the Eucalyptus Foundation Chair, teaches a variety of tax courses, serves as the senior co-director of the UC Hastings Center on Tax Law, and leads the UC Hastings Tax Concentration Program. Professor Field is widely published, and one of her areas of scholarly focus has been ethical issues that arise in tax practice. Professor Field also brings real-world experience to her topic. She has significant practice experience in federal corporate and partnership taxation, and her experience includes advising clients on the tax consequences of various sophisticated matters, including mergers and acquisitions, restructurings, security offerings, and structured finance transactions. But before I turn things over to Professor Field, I want to say that we anticipate having a question and answer session following her talk. To submit a question, please use the Q&A box and not the chat box. We'll try to get to some questions after her talk. With that, I'm pleased to turn things over to Professor Heather M. Field. Thank you.
Terrific. Hello, everybody. Let me pull up my slides for you. Good afternoon, everybody. I am honored to be here, and I want to thank Dean Freewald, Professor Lathrop, and everyone at USF for having me here today. I'd also like to extend my gratitude to the E.L. Wiegand Foundation for this opportunity to serve as this year's visiting fellow. And I'd also like to thank all of you out there in the audience, wherever you may be, for joining us today. So let's start with a reflection question to set up our conversation and its relevance to you. So don't worry, you're not going to have to share answers with anyone. I'm not going to call on you. But if you can reflect on your own experience and be really honest with yourself, I think this next hour will mean more to you. Okay, so for folks in the audience who have practiced tax law, think to yourself, have you ever withdrawn from a client matter because the position the client wanted to take was too aggressive for you, or declined to handle such a matter? Have you ever wanted to withdraw because of how aggressive your client wanted to be? Have you ever gotten pressure from a client to sign off on something that you had real qualms about? Have you ever gotten that kind of pressure from a colleague, or put that kind of pressure on a colleague? Have you ever regretted saying yes to an aggressive client and wish you would have been able to say no? And more broadly, for everyone, including students who may be joining us today, can you think of a time when you did not live up to your own ethical standards? When you cheated or lied a little? What caused you to depart from your own ethical standards? If it's easier, maybe you can think of an example of a situation where a friend or colleague acted unethically. Why might they have made a poor ethical decision? Are they just bad, unethical people? Or were there situations where a generally good, upstanding person made a bad choice? So almost every practitioner that I've spoken to about these issues and that has practiced for any significant amount of time has a story, though many are understandably reluctant to share the details. A situation where they disappointed themselves, or at least felt tested, perhaps torn between their duty to their client and their own sense of right and wrong. I certainly have stories from my practice experience about feeling tested. So whatever story or situation came to your mind, keep that in mind throughout our talk, because it's these situations that we're going to talk about. And that makes this talk a little bit different than other ethics talks you may be used to. Not just what are the boundaries imposed by the rules of ethics and the standards of tax practice, but also what are your boundaries? Will you do everything that's arguably allowable under our ethical guidelines? Or does your sense of morality and ethics mean that you won't go quite that far? And once you know the boundaries imposed by the rules of ethics and standards of practice, and once you have a sense about your own ethical boundaries, whether the latter are narrower or coextensive with the former, how can you increase the chances that you're holding the lines you want to hold? What are the risks, the psychological and cognitive factors that could skew your ethical decision-making, perhaps without you even realizing it's happening? So that's our agenda: ethical boundaries within which tax advisors operate and where there are opportunities for discretion. Your boundaries, we'll talk about different models of being an ethical tax lawyer, and you can see which approach resonates with you. And implementation. What makes it hard to hold the ethical lines you want to hold? We'll talk about behavioral legal ethics, the concept of bounded ethicality, and what they mean for a tax lawyer seeking to make ethical decisions in her practice. Note, by the way, the basic parameters that I'm assuming here, that we're talking about a well-intentioned tax advisor who wants to behave in an ethical manner. We're talking about people whose decision-making ends up being skewed, less ethical than they intended. We're not talking about people who intend to evade taxes, commit fraud, or otherwise intentionally behave unethically. That's not the focus here. It's people who want to do it right, which also means that we're generally talking about contestable positions, not positions that are clearly wrong or frivolous. And we're also generally talking about forward-looking advising, tax planning, return preparation. And this is practitioner focused, not policy focused. And note that I'm an academic, but I did practice for several years, as Professor Lathrop mentioned. And I'll be very interested in hearing whether and how this talk resonates with your experience for those of you out there who are practitioners. Okay, so ultimately, the goal here is to help us as a tax profession and help individual tax advisors operationalize on an individual basis and in a way that aligns with their values, the general and tax specific rules of professional conduct. So, we're going to start with a quick review of the ethical boundaries for tax advisors, particularly in the context of assisting aggressive clients. Now, I assume that most of you are pretty familiar with these rules, but I do want to hit some of the highlights. So this is going to be a rapid fire tour. So are we ready? I think we're ready. Okay, so what are the key constraints on tax lawyer behavior in the context of aggressive tax planning? Well, they include, but are not limited to, the rules of professional conduct. We're going to start with the model rules, kind of a lawyer shall not counsel a client to engage or assist a client in the conduct that a lawyer knows is criminal or fraudulent. You're required to withdraw if the representation will result in a violation of the rules of professional conduct or other law. And there's allowable discretionary withdrawal subject to some limitations at lower thresholds, including if a client insists on taking an action that the lawyer considers repugnant or with which the lawyer has a fundamental disagreement. Now, it's noteworthy that the model rules were adopted with some deviations here in California. The rules in California were revised in November 2018. And so there's some minor changes in the language, differences in the language, but a key difference to keep in mind is that California doesn't provide for discretionary withdrawal if a client insists on taking actions that the lawyer considers repugnant or with which the lawyer has a fundamental disagreement. Nevertheless, there's arguably still some room for discretionary withdrawal under similar circumstances because California does allow withdrawal, subject to limitations, if the client's conduct renders it unreasonably difficult for the lawyer to carry out the representation effectively. But the bottom line here is that because there may be fewer opportunities for discretionary withdrawal under the California rules, these rules put more pressure on declining matters up front if the lawyer has a fundamental disagreement with the client's goals. And we can talk more about this if you'd like. But let's move on to the tax-specific rules that constrain our tax advisor conduct, set outer boundaries. So we have the ABA formal opinions, don't advise on a reporting position unless there's a realistic possibility of success, and there are additional requirements if you're issuing tax shelter opinions. And what about Circular 230, which sets out the standards of practice applicable to professionals who practice before the IRS, and that's very broadly defined. Well, Circular 230 has a lot to say. You may not willfully, recklessly, or through gross incompetence sign a return or advise a client to take a position on a return that lacks reasonable basis, is an unreasonable position, or is a willful attempt to understate liability for tax, or a reckless or intentional disregard of the rules and regulations. What else? Don't advise a client to take a position on a document unless the position's not frivolous. Do not, when evaluating a federal tax matter, take the audit lottery into account, and know that if you willfully assist, counsel, or encourage a client to violate federal tax law or suggest to them an illegal plan to evade federal taxes, you may be subject to professional sanctions. And there are many more provisions of Circular 230, but those are the ones that are most relevant for our inquiry into ethical tax practice in the context of aggressive tax planning. There are also tax penalty provisions in the code, including accuracy-related penalties, which can be reduced if the advice meets certain thresholds. And there are lots of other potential penalties for assisting with aggressive tax planning. And if you're advising on reportable transactions, you've got to comply with list maintenance and disclosure requirements, noting that lack of compliance triggers penalties. And don't forget other constraints, including the federal criminal code. A lawyer involved with aggressive tax planning could be subject to criminal charges for aiding and abetting tax evasion, for conspiracy to commit tax evasion. There are also malpractice claims. If aggressive tax planning is successfully challenged by the tax authority, well, and the client owes additional taxes, interest, and maybe penalties, client's likely to turn around and sue the lawyer. Now, lawyers are generally only liable if their conduct breached the standard of care, but the prospect of getting sued by a client does constrain lawyer behavior, at least to some degree. So that's obviously a quick and incomplete summary, but my goal here is just to remind all of us of some of the boundaries within which we provide tax advice, particularly when assisting aggressive clients. These and the rest of the ethical rules constrain our behavior by setting outer boundaries. But within these boundaries, we actually have a tremendous amount of discretion. So where do you draw your line? For example, within your expertise, will you assist with every transaction that the rules allow you to? If not, how do you decide what you will do and what you won't? How aggressive are you willing to be within the boundaries of what is allowed? Will your relationship with your client be one where you just do what the client requests, or will, and in what circumstances will, you try to persuade a client to do something else? Will you consider only the client's interests when advising the client? Or will you also consider interests of others, including the interests of the larger tax system? How will you answer questions from the client about the likelihood of audit? Under what circumstances will you withdraw? And if you decline or withdraw from a matter because of how aggressive it is, will you provide a referral? And there are many, many more questions that you have to make discretionarily within the outer bounds of the ethical rules. And this is where we started with the reflection questions that I posed to you at the beginning of our time together. So my research on the topic of ethical lawyering, particularly in the context of advising on aggressive tax planning, leads me to the following recommendation. In addition to knowing the relevant outer boundaries on ethical behavior that we just reviewed, tax advisors should identify their own boundaries. What model of ethical tax advising resonates with them and why? That will provide guiding principles for answering the hard discretionary questions in a way that is consistent with their values. And tax advisors should be aware of and work to counteract behavioral factors, including cognitive biases, that can skew their ability to abide both by the outer boundaries established by the professional conduct rules and by the ethical ideals to which they personally subscribe. So those are the second and third parts of the talk. So we're going to talk about each of these aspects kind of in sequence. So let's turn and talk about models of tax advising. So two quick caveats as we do this. One, I'm not going to push any particular approach to tax advising on you. With very limited exceptions, I think that any of the approaches I'll discuss can provide reasonable principles for ethical tax advising. My goal is just to facilitate your own reflection so that you can identify for yourself the principles that you want to help guide your career. And the second caveat is that my guess is that the practitioners here with us today have already adopted a particular model of tax advising, but it may just be implicit. You, like many tax advisors, you may not have articulated explicitly or really spent much time reflecting on why you approach tax advising the way you do. I certainly didn't when I was in practice, right? It's enough to do kind of what's necessary to address all the client work, especially in a pandemic. So part of my goal is to provide you with a framework and opportunity for doing this reflection. So as I run through several different models of tax advising, I invite you to think about which approach or approaches most resonate with you. And no, there's a huge amount of literature on professional role conception for lawyers using a lot of different terminology, and this discussion draws on that. Okay, so a tax lawyer might approach their role as a hired gun, empowering client autonomy. This lawyer will take any action that advances the client's interest as long as the action does not clearly violate a rule of ethics or other law. And the hired gun is willing to factor in the risk of penalties into the cost benefit analysis they discuss with the client. And they're willing to help the client take a position that likely subjects the client to penalties if, on balance, there's a net positive present value to the position. Now, being a hired gun, taking a hired gun approach, does not necessarily mean that the tax advisor will facilitate aggressive tax strategies, but this approach does reflect a willingness to empower even aggressive clients, and even if penalties might apply. So under a slightly more conservative approach, a lawyer draws the line where penalties would apply. So this lawyer will assist a client in doing whatever is allowed under the law, but without an imposition of a penalty or sanction. So unlike the hired gun, they won't be willing to assist a client in taking a position that likely triggers penalties, but they'll go up to that line. And more conservative yet would be the tax advisor as ideal judge. This is a legalist philosophy, and this tax advisor only wants to help clients take positions that are more likely than not the right answer, right? Okay. There are a couple of approaches that are less about conservative versus aggressive and more about the relationship between the lawyer and the client, but they're worth reviewing here as well. One is the tax advisor as guru, and this terminology comes from the literature, it's not mine. So this tax advisor uses a philosophy of morality. The lawyer makes moral choices for the client and helps the client take actions and positions that the lawyer believes to be morally meritorious. And there can be a very strong ideological component to this. And this lawyer may withdraw more frequently if they can't convince the client to take what the lawyer believes is the moral action. There's also the tax advisor as friend and counselor, where you collaborate with the client, providing counseling to help the client make well-considered decisions, taking account of all relevant factors, including the non-tax impact on the client, the impact on others, and on the broader tax system. There's also the self-interested approach. This approach is clearly ethically problematic, but it's important to mention anyway. And a self-interested tax lawyer would do whatever is in the tax advisor's interest. Although it's not always clear what that is, because it could be that the tax advisor has a personal interest and is driven by the desire to avoid penalties or sanctions, which would lead them to take a relatively conservative approach. Or it could be that the advisor is more interested in keeping clients happy and kind of getting clients, which could lead to a potentially aggressive approach. And there could be other meanings of self-interest as well. There are other approaches too, as well as combinations. So before we talk a little more about the reasons why people go one way or another, let me say a few words about why all of this matters. Well, someone who develops her approach to tax advising thoughtfully gives herself a framework for principled decision-making that she can use when responding to difficult clients and handling challenging decisions. And by considering her concept of an ethical tax advisor outside the context of client pressure, outside the context of the competitive market for business, she can anticipate and prepare for situations that might push up against her notion of an ethical tax planner. And this increases the likelihood that she makes difficult decisions in a way that is aligned with her values, the values that she wants to guide her practice. And moreover, having an articulable approach to tax advising helps the tax advisor to differentiate between tax planning that she believes is legitimate and with which she's willing to assist, and other tax planning with which she will not assist. One's approach to tax advising can also result in very different advice for clients. But even if the approach to tax advising doesn't change the substance of the advice, a tax advisor's approach to ethical advising still matters. And this is for at least two reasons. The first has to do with the impact on the client. Clients are going to have very different approaches, different experiences of the lawyer-client relationship depending on the lawyer's approach. And an advisor who explicitly identifies their advising approach can serve their client better. Knowing your advising approach makes it easier to identify clients whose needs you're more likely to be able to meet. And you can use the articulation of your advising approach to help set expectations for the representation. And when you match the advisor's approach with the client's preferences, that increases the likelihood that the client will be satisfied with the advice. Or think about it this way. A very aggressive client would want to know if you generally take a legalist approach, they probably shouldn't hire you, and you probably don't want them to. Okay. So the second reason one's tax advising approach still matters, even if it doesn't change the substance of the advice, is because of the impact on the lawyer herself. Identifying and implementing an advising philosophy, an advising approach, helps an advisor maintain her personal integrity and her inner moral compass in her professional life. And research on career satisfaction for lawyers indicates that practicing in accordance with one's values helps to make practice more satisfying and sustainable in the long run. Okay, so none of that, though, provides instruction about which approach to tax advising a particular advisor should adopt. Now, perhaps you have a sense, based on my brief descriptions of the models, about which approach most resonates with you. But let me say a few words about considerations that might or might not affect your choice. So one consideration is the limited government resources available for enforcement, which leads to a relatively weak enforcement mechanism for the tax system. As a result, the government cannot be presumed to be a reliable adversary to all taxpayers, and the tax system relies heavily on self-assessment and taxpayers' willingness to comply with the law. And for some advisors, this is a compelling reason to adopt a more conservative approach to tax advising, often towards a legalist approach rather than a hired gun. On the other hand, other advisors will conclude that as long as they're not taking advantage of the resource imbalance, for example, by encouraging clients to take advantage of the audit lottery, then this consideration shouldn't affect their approach to tax advising. Now, a related but somewhat broader concept that might influence a tax practitioner's choice of advising approach is the notion that tax advisors may have a special gatekeeping duty to protect their revenue. Some commentators argue that tax advisors must balance the immediate demands of their client against the public's interest in a sound tax system that operates as Congress intended. Now, admittedly, people debate about whether tax lawyers owe a special duty to protect their revenue beyond the general duty that lawyers have to obey and uphold the law. What kind of duty do you think tax advisors have to the tax system as a whole? There are a variety of other considerations relevant to the choice of tax advising approach. People might take a different approach in the prospective advising and reporting context as opposed to the controversy context. Similarly, a tax advisor might take a different approach where the client's actions are primarily tax motivated, kind of as opposed to situations where the client is pursuing a non-tax business objective that they hope to do in a tax favorable way. And a tax practitioner's approach may also be affected by the extent to which she's concerned about the historic role of tax advisors in sheltering and evasion, the erosion of public confidence in the tax system, and the rise of anti-tax rhetoric. Maybe these things affect your approach, maybe not. But given the existing rules, there's no consensus about the one right approach, though clearly the pure self-interested approach is not the way to go. Setting that aside, this is a highly personal choice. And of course, a lawyer may not be able to implement their approach fully given their employment situation, and their preferred approach may evolve over time. And they may tailor their approach to the practice specialty area, the practice setting, the sophistication and needs of a particular client, and more. So this is part of the framework that I'm offering for ethical tax lawyering in the context of potentially aggressive tax planning. 1, know the outer boundaries imposed by the various rules constraining professional conduct. Know what your boundaries are. Identify how you will approach your professional role in light of what ethical tax advising means to you. But these things knowing where these boundaries are, it only works to help you be an ethical advisor if you can turn your knowledge of the boundaries into action. So, for example, if you're willing to advise on the substantial authority position taken without disclosure, you want to make sure that your judgment is right about whether there is actually substantial authority. You don't want to inadvertently sign off on something that is more aggressive than you intended to sign off on. So let's talk about staying within the boundaries, because it turns out that making principled decisions is harder than it sounds. Every professional thinks she exercises solid professional judgment, that she makes ethical decisions. And most people intend to stay within the lines, whether we're talking about the outer boundary set by the ethical rules or internal boundaries set by an individual for herself. But ethical lapses are easier to make than generally anticipated, and good, well-intentioned people cross the line. Why? So I don't have all of the answers, which may frustrate you given that you've joined us today, but I do have some thoughts. Because there may be many factors at play, right? It could be, as we've discussed, that they don't know the ethical rules, although I don't think that's really the problem. And it could be that there are ethical lapses because, as we've discussed, people haven't really thought about what it means to them to practice in accordance with their values. But there's another really important issue that we need to talk about, and that is people make decision-making errors. And behavioral legal ethics provides insight into these decision-making errors. So what is behavioral legal ethics? Behavioral legal ethics is a discipline grounded in decades of empirical research from behavioral science about how people make decisions. And this research demonstrates that cognitive biases can lead to unintentionally flawed decision-making. And behavioral ethics is part of a growing area within this research about ethical decision-making behavior. And the basic idea is that even people who want to behave ethically can be affected by psychological factors that are outside their consciousness, causing unethical behavior contrary to their own intent. And behavioral legal ethics applies that behavioral science and behavioral ethics research in the context of legal ethical decision making. So, one thing that may be going on when good lawyers make bad choices is that people, even including tax lawyers, are boundedly ethical. There are systematic and predictable organizational pressures and psychological processes that cause people to engage in ethically questionable behaviors that are inconsistent with their own preferences. Various factors can cause us to make unethical decisions that we later regret. In the context of legal ethics, the result is that well-intentioned lawyers may act in a way that is contrary to their ethical values and will often be unaware about how their behavior diverges from their own conceptions of themselves as ethical and honest people. So an important caveat is merited before we get into the rest of this discussion, and that is there's a lot about behavioral ethics, particularly behavioral legal ethics, that we don't know. This is an evolving field with ongoing research, and many of the insights that I'll talk about today are from experiments rather than natural observations, and many of the insights are from research that's not law specific, certainly not tax law specific, so there are questions about the importability of these insights into the legal context. But also more generally, human decision making, including ethical decision making, is complex and it's nuanced. So none of this is universal or absolute. But with that caveat, how is it that people who believe in ethics and honesty can act unethically and just ignore an ethics problem or justify to themselves why their actions are not wrong? As you'll see, a driving factor behind a lot of what I'm going to talk about is that people generally have a need to maintain an ethical view of themselves, even while they act in their own interests or otherwise commit ethical lapses. So there's there's a tension and an issue of reconciliation. So there are many mechanisms and factors at play. And what I'm going to do is I'm going to go step by step in the decision-making process and talk about the behavioral issues that can affect each step. So when you think about making decisions, I think of these three steps. First, awareness. And in this context, if you're not aware that there's an ethical issue inherent in a decision, it's pretty hard to make an ethical choice. And second, analysis. Once you see the ethical issue, you have to be able to analyze it objectively and determine what the right course of action is. And third, action. Once you know what the right course of action is, you have to be able to act on it. So let's discuss some of the behavioral issues that arise at each stage. Note that as I proceed, you may think, that's not me, or I'm not affected by that. And it may not be you, and you may not be affected by that. But I hope you keep an open mind. And for whatever it's worth, I want to flag for you the phenomenon that research often describes as moral forgetting. That is, research shows that people often misremember their actual behavior, thereby enabling them to view themselves as ethical in hindsight, even if they weren't. So it's possible that we all might have been affected by subtle behavioral factors in the past without even realizing it. Okay, so awareness. There we go. If people don't perceive the situation as posing an ethical dilemma or choice about principles, people are more likely to make their choice without taking the ethical dimension into account. And this can happen to lawyers. They can have ethical blind spots where they just don't see the decision as involving an ethical issue. Or they may be subject to ethical fading, where the ethical dimension of a decision kind of fades into the background, leading people to overlook it. So how does this happen? There are several mechanisms, and let me mention a few. One is the illusion of objectivity. Research demonstrates that people often incorrectly view themselves as more objective than others, and they're overconfident in their ethical self. This creates ethical blind spots because they think they can be objective. For example, people may anticipate that others may allow financial incentives like the retention of a client to trump principled decision making, but they generally believe that they will not succumb to such a tendency, so they're not worried about any kind of ethical issue there. There's also an issue of framing. People can fail to focus on the ethical dimension of a decision because of how the issue is framed. Researchers have shown that this can happen, for example, when money is made the most salient feature in a particular decision. Then people are more likely to invoke a business frame to the question, viewing it through a business lens rather than viewing it through an ethical or morality frame. An example from the research is when a daycare center added fines for parents who picked up their children after the daily deadline, the goal was to reduce the tardiness, but actually tardiness increased. In part because the fines reframed the action from an ethically tinged one, oh, I shouldn't be late and put this extra burden on the staff unfairly, to a purely economic one. Well, I can pay X dollars and effectively buy the staff's time to watch my kids some more. So framing, particularly this type of framing, is something that could easily affect tax lawyers because tax issues are generally framed as business issues, as money issues, rather than as issues of ethics or morals. We don't usually talk about it as an issue, for example, of civic responsibility. And moreover, the way that much of the tax compliance infrastructure is set up does this for us. By establishing certain monetary penalties for certain degrees of aggressivity in positions, that can predispose us, I think about aggressive tax planning through a business or economic lens rather than through an ethical lens. What else? Incrementalism. You're probably familiar with the old story about the frog in the pot of water where the temperature gets increased so slowly that the frog doesn't notice he's getting boiled. Incrementalism. And incrementalism affects ethical decision making too. The idea is that people may just fail to notice that they've slowly moved into an area where all of a sudden there's a real ethical issue that's present. They may not notice that over time their decisions have evolved from small technical things to larger, perhaps fraudulent noncompliance. And people can also overlook an ethical issue because of conformity bias. Conformity bias is the phenomenon that people take their cues about proper behavior from their peers, about what is and isn't an ethical issue. So if their peers are overlooking an ethical issue or cutting ethical corners, those around them might too. And this might be peers at your firm, peers in professional organizations. And relatedly, there's the notion of obedience to authority, where people can be so focused on pleasing their superiors that they don't even notice that their superiors are asking them to do something unethical. And these last two are concerns for junior folks in particular, because those folks are just setting their ethical compasses, right? And to do so, they often take cues from those around them. Research demonstrates that the ethical culture of a firm is an important determinant about how ethically the attorneys in that firm will behave. All right, so let's say you're aware of the ethical dimension of a choice and you proceed to analyze it. What behavioral impediments can hinder your ability to analyze the choice ethically? There are many factors here. Let me go through a few. One is that experiments have shown that line crossing behavior is more likely when participants suffer from what's often referred to as ego depletion or moral fatigue. That is, when people have more core demands on their focus, resulting from time pressure, stress, low blood pressure, etc., they're more likely to have ethical lapses, more likely to make unprincipled decisions, because it takes work and mindful self-control to make ethical choices. And fatigue is a really important component of this. People are more likely to make skewed decisions when they're tired. And we all know that fatigue can be an issue among tax lawyers. Well, all lawyers, really. And so it's something to watch out for. In addition, people can be subject to a self-serving bias, where they conflate what is ethical with what reaches the desired result, what serves their needs and preferences. And there are several related issues here. One is confirmation bias, where people have a tendency to seek evidence or interpret evidence in a way that confirms their pre-existing beliefs. And this is related to the notion of motivated reasoning, the tendency of individuals to utilize a variety of cognitive mechanisms to arrive at a conclusion that they desire through a process that appears to involve unbiased reasoning, but really doesn't. Lawyers may be responsive to explicit or implicit pressure from clients. There are studies that show that aggressive tax advice can be demand-driven, that is, responsive to aggressive taxpayers. And clients can exert a lot of pressure about getting to a particular answer about the tax consequences or getting to a particular level of confidence about the tax analysis. Those of you out there with clients probably, I imagine you know what I mean. But this kind of pressure can motivate a lawyer's reasoning, leading them to reach the desired conclusion, thinking that what they've done is gone through an unbiased process of analysis, all without realizing that their analysis has in fact been somewhat biased because of the motivation. But actually, even without client pressure, let's assume client doesn't pressure you at all. Research shows that a professional may be biased in favor of the client's interests from the mere fact of the professional representation. This is referred to as role-conferred bias, role-conferred bias. And this effect can be magnified the longer the professional represents the client. Research also demonstrates that advisors can identify more closely with a client over time thereby increasing the extent to which the professional's judgment reflects what they know the client would want it to be. Okay, what else? Incrementalism. We discussed this earlier as affecting someone's ability to identify ethical issues, but it can also affect their analysis of the ethical issues. This can be a slippery slope. This can lead a tax advisor to conclude that the tax position in a new matter has the same likelihood of success as a position in an earlier matter, even though several small changes have been made, leading to slightly worse facts, and even though the tax advisor would not have assessed the new position to be as strong had they examined the new position in isolation. Dangerous. There's also issues about vagueness. Research demonstrates that ambiguity and uncertainty provide moral wiggle room, increasing someone's ability to justify behavior and maintain an ethical self-concept, as long as there's some view under which her actions are ethical. And we all know that aggressive tax planning efforts arise in exactly those places of ambiguity. There are also a variety of other behavioral factors and biases that can hinder ethical analysis, including hyperbolic discounting. Research demonstrates that people have a tendency to discount future events, and that could lead a tax advisor to inadvertently take the audit lottery into account when they didn't intend to. And research also shows that the lack of a clear victim increases the likelihood of unethical conduct, particularly when acting on behalf of others. And this certainly could be a factor present in tax advising, where we're acting on behalf of a client, and the victims of unethically aggressive tax planning are the diffuse taxpayers across the country. So all of these factors and more could skew a tax lawyer's analysis of an ethically fraught situation, leading them to unintentionally make the wrong decision. Okay. Quick sip of water. So once you've done the analysis and you know what the right thing to do is, you still have to act. You still have to act on that determination. And again, there are a number of factors that impede people from taking the ethical action, even when they know what it is. Research shows that one such factor is that people rationalize taking the unethical course, because there are a variety of ways to reconcile the action with the concept of oneself as an ethical person. So for example, denial of responsibility. Well, that decision is really someone else's responsibility. Or denial of injury. Well, no one was really harmed. It could have been worse. Or social waiting. Well, that other firm is much more aggressive than we are. They're worse. Or appeal to higher loyalties. Look, I'm not going to say anything out of loyalty to my boss. Or, well, I'm going to do this because I have a family to feed. And that last rationalization relates to another behavioral factor that research shows contributes to people's failure to take the ethical action, and that is contextual pressures. And this is also known as situationism, which recognizes the strong effect that environmental influences can have on individual decision making. And that includes a wide range of influences, including the power of an authority figure to command obedience. I'm taking this unethical action because my boss said that I had to. Or the power of a group to exert pressure on an individual to conform to the group's perspective. This can be very powerful. So there's actually this great, pretty famous old study from several decades ago where a person, kind of the subject of the experiment, was put into a group and asked to answer a simple question. It was basically, here are two cards and one had one line and one had three lines. And the question was like, which of the lines on the one card was the same length as the line on the other card? It was pretty easy. But the other people in the group, aside from that one subject, were plants, unbeknownst to the subject. And the other people in the group were instructed to, in some rounds, just give the wrong answer. And 37% of the subjects confirmed the majority's view even when it was wrong. And while many of the subjects did resist majority pressure on one or more of the rounds, ultimately over 75% of them conformed to the majority's wrong answer at least once. And these results have been replicated in many studies since the original study. And it seems almost unfathomable that people would conform to the majority choice even when it seems clearly wrong. But some did. It leads them to question themselves. And that study was without any incentive for complying or any penalty for not agreeing. And in contrast, if you think about tax practice, law firms, there can be a lot of incentive to go with the group, even if it seems wrong. Bonuses, promotions, keeping your jobs. Do you want to make a fuss? Do you want to stand up to the rest of the group? Group pressure can be a very powerful thing. And so people who find themselves in an organization where ethical standards are eroding or were never particularly strong in the first place will be more likely to choose to act unethically. There are also experiments that demonstrate that other situational factors can lead people to act unethically. You're more likely to act unethically if you're under time pressure, if you're exhausted, depleted, and more likely to act unethically if you're trying to avoid a loss rather than seek a gain. And look, this is not a comprehensive discussion of all of the behavioral factors that can impede ethical decision-making in tax law practice or otherwise. But hopefully it gives you a sense of the subtle, often unconscious or subconscious factors that can lead good, well-intentioned people to make unethical choices. And some of these things may be more prevalent in tax practice and some less so, and some may resonate with you more than others. And to be clear, I am not saying that any of you have behaved unethically. I'm just saying we're all human, and we should be aware that human decision-making can be skewed by a variety of unconscious factors. All right, so you might be wondering, so what can we do about all of this? This doesn't sound good. Well, there's no panacea. But the understanding that biases can skew decision-making and judgment is a step in the right direction. The more aware someone is about the subtle and situational and cognitive factors, the more they can prepare to counteract them. For example, knowing about the impact of incrementalism can encourage lawyers to be vigilant about ethics, even in situations where there are only small changes from prior matters. And there are a lot of different strategies for helping to navigate situations that either overtly or subtly test your ability to hold the lines you want to hold, but no guarantee. One strategy is being explicit with yourself, the firm, your colleagues, and clients. With yourself, there's at least anecdotal evidence that suggests that people can improve their chances of acting ethically by thinking in advance about ethical issues they may run into in their careers and thinking carefully about how they intend to respond to them. And this goes back to our discussion about lawyering approaches and how you want to handle discretionary choices. In addition, being explicit with yourself includes intentionally pausing to try to identify ethical dimensions of decisions to increase their saliency. And with your firm and colleagues, identify the lawyering approaches in the firm and professional community. How do you think your colleagues would describe their advising approaches? What would be the kind of theory behind the firm's approach? If your advising approach is aligned with your firm's, great. Just think about how the firm, not just you, can stay true to that firm's approach, and we'll come back to that in a minute. But if your approach to advising is not quite aligned with your firm's, you got to identify the places of difference. What might those places of difference mean for you and your ability to live up to your vision of ethical tax lawyering? It's also worth being explicit with your clients, talking to your clients about the relationship expectations and your tax advising approach so your client can know who you are and how you approach advising when they decide to engage you or not. In addition to being explicit about advising approaches, it can also be useful to have reliable processes that you can use for a check on difficult judgments. And there are a lot of different ideas here, and you and your firms may already implement several of these. One is perspective taking. That is, biases can be lessened if the decision maker consciously seeks to engage in thinking that supports the contrary position, kind of the position that's contrary to their desired result. So for example, you might have a regular practice of making the best counterargument possible, as if you work for the IRS. Or maybe you appoint one member of your team to be the devil's advocate, kind of to try to tear down your arguments as best they can. Or as a journalist writing an expose. Perspective taking can help the decision maker see a matter more objectively without the factors, or at least with a less impact of the factors that are likely to produce biased reasoning. Other ideas include obtaining counsel from someone who can view the situation more objectively, maybe second partner review or an opinion or ethics committee. Also, if possible, do not make decisions when fatigued. Final decisions, right? Sleep and reconsider. And there are other ideas as well. And lastly, beware of red flags. Now, red flags don't necessarily mean you're doing anything wrong, unethical, or that is otherwise inconsistent with your values. It's just an opportunity to have heightened awareness. If you think or hear yourself saying, well, just this once, or the other firm did it, or, well, if we don't, the client will fire us, or, well, that's what we concluded last time, right? Or, I mean, it's so close. Does it really make a difference? Or, well, this is really just a business issue. Or, well, my supervisor says it's okay, so it must be. Red flags. So ultimately, there are several other strategies for counteracting decision-making biases as well, but these are several that might be useful. So let's return for a minute to the scenario that you thought of in the beginning when I asked you whether you'd ever had any hard calls or felt tested. If you handled that matter in a way that reflects your vision of ethical lawyering, I hope this presentation has given you even more confidence and comfort about your approach, and even more tools to help you stay on the right course, to continue to live your ethical values in your professional practice. But if in retrospect, you wish you had handled the matter differently, noting that there is no shame in learning from past experience, I hope this presentation has given you some tools to help you approach such matters differently in the future so that you can more effectively implement your vision of ethical lawyering, particularly when advising aggressive clients. And if you've been lucky enough not to have faced one of the types of difficult situations I described, I hope that this presentation gives you some tools to help you prepare to deal with such a situation as effectively as possible and in a way that aligns with your values as much as possible, if such a situation ever arises for you in the future. So with that, I'll say thanks very much for your attention, and I look forward to your reactions. All right, let me pull this down. And
all right, there. I was able to get the camera back on and the speaker. First, Professor Field, I'm certain everyone joins me in thanking you for a very interesting presentation. I'm sure for all the professionals out there, you've stimulated a lot of reflection regarding things that have happened in their practices and perhaps how to deal with things in the future. We have a couple of questions that I'd like to get to. The first is a simple one. Is there any empirical evidence regarding the tax advising models that are actually used by tax professionals? Is there anyone who's tried to, for example, quantify the percentage of professionals that are hired guns versus those that might use penalties as an outer bound or might use a more likely than not kind of standard in their life, professional life?
So not to my knowledge. The IRS does kind of periodically survey practitioners to get a sense about what kind of their kind of experiences are, but I have no information about anybody doing anything more directly on point here to try to find out what's really happening out there in kind of in practice. And all I could do at that point would otherwise just be speculation. But it'd be really interesting to know.
Yeah, it would be. A question came in about advising a client. We're going to get some questions that are about particular fact patterns. The question's essentially this. You advise a foreign client who is about to embark on an investment or some type of activity in the United States. The individual is, you determine, not complying with the laws of another country. Those activities have nothing to do with the tax advice or the matter in the United States. Does your knowledge of this individual's non-compliance somewhere else have any impact on how you treat them or how you advise them in the United States?
So, I think, all of these questions are contextual and can be hard to answer. I guess under the fact pattern as posed, if you're not involved in any of the foreign kind of planning, I think it's a little bit easier for you. Maybe you know that has happened, but and so you may, when advising this client, kind of want to really make sure that you're providing a check on their aggressivity, make sure that you are not doing anything that kind of assists a client in reducing their foreign tax burden. I think that assisting in foreign tax evasion may be sanctionable, potentially under our professional conduct rules. If there's any connection between the foreign activity and the domestic activity on which you're advising, you want to be extra careful, especially because there's been increased amount of enforcement cooperation between U.S. and foreign countries through mutual legal assistance treaty and simultaneous criminal investigation programs. So
I think the premise of the question was that there is no connection between the non-compliance abroad and either the advice you provide or anything going on here. And you have nothing to do with the non-compliance as a professional. You have nothing to do with the non-compliance in the foreign country.
So I think this is one of those discretionary places, right? This is a discretionary choice, and people are going to make different calls. I mean, for me personally, I might just want to say no thanks, because if I know that they've been engaged in kind of problematic activity abroad, I'm very worried about what they're going to do with or try to do with the advice that I give them. But different people will make different calls on that.
All right. Here's a question that I take to be somewhat a reflection on the questioner's view of the profession. It says, it seems to me that motivated reasoning is a particular problem in this context. Highly esoteric, ambiguous law. Highly esoteric, ambiguous law. IRS asleep at the switch. Increasing lawyer compensation. And a seeming race to the bottom among tax advisors. Everyone's doing it. Back in the day, lawyer salaries were more modest when law was more a profession than a business. Perhaps it was easier in that environment to avoid motivated reasoning. Do you agree? Is there any hope in these modern times?
Well, I think motivated reasoning is potentially a very big problem. I am always cautious about kind of thinking, well, back in the day, things were better, especially to the extent that I wasn't involved back in the day, so I don't have firsthand knowledge. But it's hard. And I think, law firms have increasingly fashioned themselves as businesses as opposed to kind of groups of professionals. And when taking a business approach to kind of the practice of law, I think that there's an increased kind of risk on these issues. So is there any hope here? Am I concerned about this? Yes, I am. And I think that probably just gets worse. There could be hope. I think, someone could, a firm could kind of try to take a different view, right? Like, look, we're not going to be the firm that's going to do everything in our power to help you keep every single penny you might be entitled to. We're the firm that does it right. We're the firm that gets it right. And a firm could try to establish themselves as that kind of counterexample and maybe attract clients who have that view of how they should comply with the tax law. I don't know. I am worried though.
Here's a little longer one. Professor Field, thank you for your discussion of what Dean Freewald correctly described as an important issue. Professionally, I ask myself, what would be the analysis? What would the analysis be if I'm not trying to get a particular result and when I'm not worried about financial implications like getting paid for my analysis? Under this standard, tenured academics theoretically have more freedom to engage in ethical behavior. That is also probably true for some government attorneys who are not paid a bonus for winning and who can freely settle cases based on a quote, correct, unquote, application of the law and the facts. So for those in the private sector and for those government types with an insufficient, my screen jumped, insufficient moral compass, what do you think about having professionalism codes? As you pointed out, Circular 230 and the model rules establish the floor, so to speak, of ethical behavior. Professionalism codes, on the other hand, can be the ceiling. It is not enforceable, but memorializes where the line should be drawn.
So, so a couple things in there. One is just to validate that not everybody has to go into private practice and that there are a lot of opportunities to be involved in the tax profession where one can kind of try to live and practice in a way that is consistent with their values. If they tend to be very conservative and they don't want to go kind of and be aggressive, there are options, and I certainly encourage people to take the opportunity to work in government and obviously academia. On the specific question that was posed about professional codes, I mean, I think it's an interesting idea. It's a little bit hard. I could imagine a situation where there was an articulated ideal, the kind of that this is the goal of our profession, so sort of like an aspirational ethical kind of description. And so you could establish that as like, look, the standard Circular 230 and the other things I talked about are the floor, but here's a statement of our aspirational goals as the ethics of the profession. I'm not sure how much that would achieve. And I also think that there's a lot of ways in which people can kind of rationalize that in their minds. Like, I'm achieving that mostly, or kind of technically in a large part, but I'm still doing this. So maybe, I don't know.
Okay, I'm going to ask one final question because I'm being told that we're supposed to wind up by 1:10. An interesting question that I have absolutely no idea about. I'm asked whether you have any knowledge about whether tax advisors are more at risk for professional liability issues. Any idea whether the malpractice insurance for tax advisors, how that compares to lawyers generally?
So on the empirical question of the premiums, I definitely do not know the answer to that. On the question of whether tax advisors are more at risk from the professional liability perspective, I can tell you that from what I have researched about malpractice, that there have been kind of a significant number of cases kind of in the tax area where malpractice insurers have had to pay out on account of a tax claims, somewhat disproportionate in comparison to other practice areas, kind of in terms of like tax is a small practice area, and there were kind of a somewhat higher number of claims paid out. That said, some of that comes from kind of historic shelter activity, and it's not clear how much that's going to continue to be true going forward. And I don't know, other than based on a little bit of malpractice claims data that I have seen.
All right. We're going to have to conclude now. As I said, we're scheduled to end at 1:10, which I think we've hit right on the button. So that's successful. Again, I want to join everyone who's been able to participate and who's been an attendant here. Thank you, Professor Field, for your presentation, and thank you for your time today. It's been It's been very enlightening, and I want to again thank everyone who's been part of this. Thank you.
Thanks, everybody. It's been a pleasure to be here today.